Welcome to Gifts with Purpose, decoding the types of testamentary gifts and their consequences. We are thrilled to have you join us today. My name is Jacqueline Yu, and I'm a co-chair of the Beverly Hills Bar Association's Trust and Estates Law Section. Before we begin, I'd like to take a moment to thank our sponsors: Bond Services of California, Liberty Mutual Surety, California Title Company, Pickford Escrow Company, and the Sanborn team. Now on to the program. We are delighted to welcome Mark Stern and Julia Hay as the speakers for today's presentation. Mark Stern is a partner at Greenberg Glusker LLP. Mark's practice focuses on representing individuals in connection with the retention and disposition of their wealth, including estate planning, transfer tax planning, and premarital agreements, and in connection with obtaining benefits left to them by others, including estate and trust administration and probate litigation. Julia Hay is a partner at Greenberg Glusker LLP. Julia's litigation experience includes high net worth disputes, high asset divorce proceedings, and probate litigation. Her entertainment practice includes successfully resolving at trial, in arbitration, complex business disputes involving profit participation, motion picture production and distribution, rights ownership, copyright and trademark infringement, idea submission, and other entertainment-related conflicts and contractual disputes. We can't wait to see what they have to share with us today. Mark and Julia, the floor is yours.
Thank you, Jacqueline. The program today is going to talk about the different types of gifts that exist and the consequence of those gifts, of different types of gifts. We don't know where you fit in the spectrum as an attendee, whether you're a drafts person. We hope that what we have to share will be helpful for the drafts person, also for the person who's on the administration side. If you are given a trust or you're dealing with a trust following somebody's death, you need to know and understand the rules and who's going to get what. Obviously, what the draft side it affects that. If you have questions today, we will do our best to answer them. If you want to just put them in the question screen at the bottom of your of the Zoom, and if we're not able to get something during the program, then we will circle back and try to get to it at the end of the program. Without further ado, Julia is going to start and talk about the different types of gifts that are out there.
Thank you, everyone, for joining us today. So we'd like to start off by going over these 6 different categories of testamentary gifts, which are specific, general, demonstrative, pecuniary, annuity, and residue. And so we'll go through each of those. So starting with specific gifts. A specific gift is a transfer of specifically identifiable property. So, for example, a ring, a painting, a car, a piece of real property, or an interest in a company or an LLC. You're transferring specific rights. And some very, straightforward examples: I give my diamond ring to Kelly, or I give my home at 123 Main Street to the trustee of the home trust. Another example: I give my membership interest in Acme Widget LLC to Fran. So, the key here is just making sure it's a very specific gift. Now, by contrast, a general gift is a transfer from general assets of the transfer that was not given as a specific gift. For example, instead of saying I give my diamond ring to Kelly, it would be I give one of my rings to Kelly, but it would not be a specifically identified ring.
Next slide, please.
Due to the unspecific nature of general gifts, we would always try to avoid those and try to make a specific gift if possible. The next category, a very common category of gifts, is a pecuniary gift. And a pecuniary gift is a specified gift of money. For example, I give $10,000 to Kelly. I give, $50,000 to each of my grandchildren. Or, for example, I give the maximum amount that I can leave free of tax to a specific beneficiary or trust. So here, the key is it has to be a fixed dollar amount or a dollar amount that is determinable by the provisions of the trust or the instrument, the estate instrument. So it can also be, on another example, I give Blake an amount equal to the value of the Acme Widget LLC memberships that were given to Fran. So again, a money gift that is specifically identifiable. So going to the next category would be an annuity. Now, an annuity is a pecuniary gift that is payable periodically over time. Some examples, Kelly shall receive an annuity of $10,000 for a period of 5 years after my death. Another example, Fran shall receive monthly payments of $5,000 during their lifetime. So once again, there has to be a fund from which the annuity is paid, and it has to be done over a period of time. So, and then the next category is a residue gift, which is the remainder. It's a transfer of property that remains after all specific and general gifts have been satisfied. So it's effectively the remainder of the estate. So, for example, I give the residue of my estate to Kelly, or you can also divide that between different beneficiaries. I give the residue of my estate 40% to Kelly and 60% to Fran. Another example, I give it to, all of your children by right of representation. I give the residue to my residue of my estate to my issue who survived me by right of representation, which would then pass to their children as well. And then I give the residue of my estate to the marital trust. So again, it's the leftovers, and you're choosing where the remainder will go. Okay, so now, that's a general overview of the types of gifts. But what does the recipient actually receive from each of those gifts? So if it's a specific gift, the recipient will receive the specifically identified and gifted asset. If, for example, there is a mortgage encumbering the asset, they also will take on that asset with the mortgage encumbering the asset, even if there is a general clause in the will to pay all debts. And they also will receive the net income from the asset starting from the date of death. Okay. Now, the question here is about expenses. If there's expenses, including property taxes and income that exceed the income, then the net expense is borne by the state for that first year. So I, as Mark and I have said before, it's kind of like the first year free examples. So if there's expenses that are incurred, they're borne by the state for the first year until the first anniversary of the testator's death, or until there's been a distribution of the property to the beneficiary, or the beneficiary takes possession of the property. So that is essentially a way to keep the expenses with the estate until one of those three events occurs, or the beneficiary in some instances can avoid incurring those expenses for that first year. And again, the allocation of expenses is based on when they accrue, not when they are paid. And in this instance, the same rules apply both to estates and to trusts under the probate code. And I believe Mark has some specific examples.
So going back to the last slide for just a second, one of the important things that Julia said is that by holding the property in the estate for the first year, the estate will pick them up, the expenses, if the expenses exceed the income. Whereas if it's distributed out, then the expenses get shifted over to the beneficiary. And so there may be either some tension or some opportunity to shift or have one versus the other pay by deferring the distribution. If you just make the distribution 2 months after the date of death, then the beneficiary will pick up those expenses attributable to that property after the distribution, rather than having the estate pay for it for the first year. Going to the next slide, it is not, we all in elementary school learned that addition was associative. That means that you can either do 2 plus 4 and then add 3, or you can do 4 plus 3 and then add 2. It doesn't matter the order in which you do it, it's the same. That's not the case here. There's an example. If in year 1, the property, this is now the specific gift, generates income of 100 and has an expense of 60, then in the first example, the beneficiary will receive $40 on account of that net income. And in year 2, when it's not the estate paying because it's charged to the beneficiary after the first year, those are reversed. The beneficiary will be charged the negative 40. So the net is the beneficiary will end up with 0 and the estate will end up with 0 of income. Because again, they offset the 40 overage and the 40 shortfall. If instead you switch it so that the first year there is net income of 40, then the second year there is, excuse me, I said it backwards. In the first year, there is a loss of 40. There's expenses in excess of income of 40. Then the estate will pick up that 40. And in the second year, you have net income of 40. The beneficiary will receive that. In this second hypothetical, because of the timing and the way it occurs, the two do not offset, and the estate pays the 40, the beneficiary receives 40, and there's a net of 80 difference there. Whereas in the first, they offset. So again, you can get radically different results, and you have to actually look and see what happens during each period. As Julia said, it's when they accrue, not when they're paid. So you can't shift this by simply refusing or delaying payment.
Right.
Next slide.
Next slide. Now, in a situation where a specifically gifted asset is sold by the estate, the beneficiary receives the proceeds from the sale plus interest on the net proceeds beginning on the first anniversary of the testator's death. So again, there's that year gap, and any interest on those proceeds would stay with the estate for that first year. And then after that first year, the interest would then go to the beneficiary.
And note that it's not the net proceeds just as they morph, it's the interest on the net proceeds. And we'll talk about that later. My guess is that today, most accounts aren't generating sufficient interest income to offset the interest that is payable to the beneficiary.
Okay. And now we have a specific example that Mark will share with us.
I actually was faced with this recently in the last several months. The individual died in September of last year and had a home in Pacific Palisades. They left it to Charity C. The home, like many properties in the Palisades, burnt down in January. In March, the trustee, because again, these rules apply both equally to trusts and estates, the trustee said, we'd like to distribute this property to you for X, Y, and Z reasons. And the charity contacted me and I said, no, I don't think that benefits you. If the property continues to be held by the trust, then the trust will need to pay the expenses through September of 2025, which include property taxes and insurance. Yes, maybe there's no insurance for a dwelling, but there's still liability insurance for the property. And so the estate will pick all those up if the property is retained by the trust estate through September. And I don't see any benefit charity to getting the property early, specifically in this case, because there's a lot of vacant lots in the Palisades, and it's not like there's any opportunity to quickly sell it. The supply is much in excess of demand in the Palisades right now. So on balance, the charity said, no, it's not worth it. We'll consider taking this in September when we don't have to pick up the expenses, and we can push off more of the expenses to the trust for a longer period of time.
Okay. And then going to the next slide, another example with a specific gift. If a specific gift is a gift of securities, that would also include securities received from stock splits, acquisitions, reorganizations, or reinvestment plans. However, it would not include pre-death cash dividends. Those would not go to the beneficiary. Okay. And then, yes, we can go to the next slide. Okay. Now, if a specifically gifted asset was sold during the testator's lifetime, the beneficiary is entitled to receive any unpaid portion of the purchase price and any security for that obligation, any unpaid eminent domain award, and any unpaid fire or casualty insurance for recovery or injury to property. So then some more examples. If a specifically gifted asset was sold during the testator's lifetime, however, by their conservator, their agent under a durable power of attorney while incapacitated, or the trustee of their revocable trust while incapacitated, then the beneficiary would be entitled to receive a pecuniary gift in amount equal to the net proceeds of the sale. And these same rules would apply during if an asset is taken by eminent domain during this period. And there are some exceptions that do apply to this.
So the purpose of these rules generally is that if the testator did not direct the sale, the law tries to carry out the testator's wish that the beneficiary receive that property. And we're going to see how the purpose of these rules, that the beneficiary not be deprived because somebody other than the testator sold it, carries out in some of the exceptions.
Okay. And then again, similarly, if a specifically gifted asset was encumbered during the testator's lifetime by their conservator, their agent under a durable power of attorney while incapacitated, or the trustee of their revocable trust while incapacitated, the beneficiary is entitled to receive a pecuniary gift in the amount equal to the outstanding encumbrance amount on the date of death. And again, there are some similar exceptions that apply.
And again, the purpose of these rules is to ensure that the beneficiary gets what the testator intended when somebody other than the testator has made the income.
Okay, go to the next slide. Okay, and the rules we just discussed relating to a sale or encumbrance by a conservator do not apply if the conservatorship is terminated more than 1 year before the testator's death. If there is an adjudication of the testator's incapacity, an adjudication of the testator's incapacity is not required for the agent action rules to apply, and the principal is presumed to be incapacitated when the action was taken. An adjudication of the testator's incapacity is also not required for the trustee action rules to apply, although there is no presumption of the principal's incapacity. Do you want to expand on that?
Going back to that last slide for 1 second, again, the first exception here is that if the testator recovers capacity such that the conservatorship is terminated and it goes on for more than 1 year, the presumption is that that person will fix and address whatever happened while they were incapacitated. That's the purpose of that exception.
Okay. All right. And then moving on to pecuniary gifts, which once again are a fixed dollar amount gift. So the beneficiary would receive the amount specified and also interest at 7%, 3% under the legal rate, beginning on the first anniversary of the testator's death. So if those gifts are not satisfied within the first year and are paid out after that first year, the beneficiary would receive interest beginning on the anniversary of the testator's death, and the interest accrued during that first year would stay with the estate. And these same rules also apply to trusts under the probate code. Okay. Now, with respect to an annuity, what does the recipient receive? Again, that's a pecuniary gift payable over time. They would receive the amount specified, payable at the end of the period, specified in the instrument. Again, interest at 7%, 3% under the legal rate. If not paid when due, again, except that no interest accrues during the first year after the testator's death. That's that same 1 year rule, and the interest would stay with the estate. And these rules also apply both to trusts under the probate code. So now moving on to the residue, which is kind of the remainder of what remains after all specific and general gifts have been made. What does the benefit recipient receive? The remaining assets after all other gifts have been satisfied, the remaining net income to be distributed pro rata to the residuary beneficiaries. And an important note here is that fiduciary fees, legal and accounting fees are also charged to the residue. So that would come out of the residue. And these same rules also apply to trusts under the probate code.
As an example of that last one, I'm dealing with a situation where a beneficiary was given a gift of real property that was sold several years ago, and the trustee has since resigned, and we're looking to get a new trustee. The beneficiary said, we'll agree to new trustee X if new trustee X agrees that they're not going to take any fees out of our gift. And the response was, well, that's what the law provides. So, you don't have anything to worry about. And shortly thereafter, beneficiary agreed to allow the new trustee to start serving.
Now let's talk about satisfaction. So certain testamentary gifts can be satisfied during the testator's lifetime. In the situations where this would occur is that the testamentary instrument provides for satisfaction. The transferee executes a contemporaneous writing indicating that the transfer is in full or partial satisfaction of the gift, and the gift is the same property as the specific gift.
Let me give an example of that first one. I do many estate plans which say I give $1 million to charity X, reduced by contributions to charity X made during my lifetime.
Right. And then in other examples, if, for example, you were providing to give $100,000 to a specific beneficiary, full or partial satisfaction can be made during the lifetime if there is a specific contemporaneous writing indicating that that transfer is intended to satisfy the gift in full or in part. Okay. So, and where there is satisfaction, the amount of the satisfaction will be determined on the earlier of the transferee acquiring the property and the transferor's death, or the transferor executing a contemporaneous writing indicating that the value is conclusive. And if the recipient of a lifetime gift that satisfies a testamentary gift predeceases the transferor, the gift is still fully or partially satisfied unless the transferor provides otherwise in writing. That's straightforward. So here are some examples, I guess, that we were just discussing. So there's a gift in trust is $100,000 to Fran. If Fran predeceases the settlor, the gift is to be distributed to Fran's issue who survived the settlor by right of representation. But however, the transferor, while alive, gives Fran $20,000. So after the $20,000 gift is made, Fran then dies. So what happens? The remaining 80,000 goes to Fran's issue. Okay. Do you want to
Okay.
intro?
So is this mine?
You can start.
Okay. So there's a whole bunch of reasons why gifts can abate, that the estate will not, or the fund will not be, trust or estate will not be sufficient to satisfy the gifts, such as creditor claims, payment of taxes, need to satisfy a gift to an omitted spouse or child, so property that was not intended or expected to be siphoned off gets paid elsewhere. The value of the estate goes down, or redemption, sale or loss of specific assets that Julia will discuss.
Yeah.
Well,
So there's a couple different examples where there, I guess, has been abatement found by redemption, and then when there has not been abatement found. So, for example, so a mere change in form of an asset doesn't result in abatement. For example, if you change the corporate form from a partnership to a corporation, or if there's a reorganization of a corporation, or in one instance, there's a case where two strands of pearls were then became one strand, and they found that there was no abatement. However, some contrasting examples where there was abatement, if you find a bank account was closed and the proceeds were used to purchase securities, that gift does abate. And then another fun example, a mink coat that was cut into a mink stole, and the court found that that change of form of the gift did abate. Another example, land transferred to a note would not.
The amazing thing about the mink coat, mink stole, and 2 strands of pearls and 1 strand of pearl is that there are actually California cases addressing that. These were litigated to court appellate decisions.
So yeah, we're not just making up those examples. So if there is abatement, the gifts will abate in the following order. First, property not disposed of by the instrument, residuary gifts, and then general gifts, first to the transfer's non-relatives and then to the transfer's relatives. And then for specific gifts, it would be to the transfer's non-relatives and then to the transfer's relatives. And relative is a person to whom property would pass from the transfer under California intestate succession if the transfer died intestate and there was no other person having priority. So there is a priority given to preserve gifts to the transfer's relatives.
And again, under this definition, a grandchild can be a relative and is a relative, even though the intervening parent is still alive.
Okay. So now we're going to go ahead and look at some of the tax consequences of these different gifts, and Mark is going to take the lead on this part.
Okay, so Julie has covered who gets what under various scenarios. If there's more by virtue of net income, or if there's less because there's been a satisfaction or abatement, who's going to bear that or who's going to enjoy that. Now we're moving to the tax consequences because we have to understand who gets the tax liability in various scenarios. And most entities are either taxable like an individual or a C corporation, or a pass-through like a partnership or S corporation. And the unique thing about trusts and estates is that they exhibit characteristics of both. Sometimes they're a taxable entity and sometimes they are a flow-through. And the linchpin for that is something called the distribution deduction. If there's a distribution deduction, then the income is that the trust or estate gets to deduct flows through to the beneficiaries and they're taxed. And the portion of the trust or estate income that is not part of the distribution deduction is taxed to the trust or estate. The distribution deduction is based on something called DNI, which is distributable net income, a big term in the Internal Revenue Code under Section 643. Next slide, please. What is DNI? You start with income generally determined in the same manner as for an individual with certain adjustments. It is very different from fiduciary accounting income. Basically, what Julia just went over was fiduciary accounting income, which is the most important. Who gets the dollars? And what I always tell clients is as long as the tax rate is under 100%, it's better to get the dollars and pay tax than not to get the dollars or property. The DNI serves 2 purposes. One, quantitative, how much? And the second is qualitative, the character of the income that is taxed to either the entity or the individual. Next slide. We're going to see this in the following example. Let's assume, hold on for a little bit second there, that the trust has relatively simple. It has a partnership distribution of 30. So for fiduciary accounting purposes, it's a receipt of $30. And so the FAI is 30. You can hit the next slide per somewhat to get to the next line. The K1 shows 20 of income. So for tax purposes, it's only 20 of income. For tax exempt income of 10, there's FAI, actual dollars received 10. The tax on that is 0. And finally, fees, the actual fees payable are 6, but for fiduciary accounting purposes, fees are charged 1/2 against income and 1/2 against principal. So there's only a charge against income of 3. For tax purposes, we have a slightly different allocation, which is that we have 20 of taxable K1 income and 10 of non-taxable income, a total of 30, and 1/3 of that is the tax exempt. So we have only 2/3 attributable to the partnership of the fees deductible, and 1/3 is not deductible. So the 6 goes down to 4 for deduction. And notice that the FAI here is 37. The person entitled to the income would get 37, but the tax here is only 16. So again, radically different. Okay. There is a rule that we'll come back to in a little bit, the separate share rule, where if an estate or trust has multiple beneficiaries who have substantially separate independent shares, those shares are treated as separate estates or trusts for DNI only. And this occurs quite regularly. Next slide. And we'll see occurs quite regularly if there's a residual gift where even to the issue. We'll talk about that later. So specific gifts. Satisfying a specific gift does not carry out DNI to the beneficiary. And again, the citations for this are in the other written materials that are included in today's presentation that have been sent by the Beverly Hills Bar Association or available from them. So there is no DNI out to the beneficiary by satisfying a specific gift. However, an amount which can only be paid from income is not considered a specific gift and therefore does carry out DNI to the beneficiary. This applies to both income items that are subject of a specific gift or income attributable to the specific gift, as I'll show in an example in an upcoming slide. Finally, the income from the specific gift is treated as a separate share. Thus, that DNI and the income from that is treated separately from other assets. As an example there, if I give Julia my shopping center at 123 Main Street, then the nature of the income that she gets is going to be rental income. And it's going to be pegged to the income of that entity, of that property. Next slide. So here's an example. If we satisfy a specific gift of Blackacre, then the beneficiary does not get any DNI attributable to that because we've simply satisfied the specific gift. However, if Blackacre generates income, and because Julie has told us that the recipient of Blackacre is entitled to receive the net income, then that income, which can obviously only be satisfied out of income, does carry out DNI to the beneficiary. So the beneficiary will receive both Blackacre and, for income tax purposes, the net income from Blackacre. Next slide. A pecuniary gift. The satisfaction of a pecuniary gift does not carry out DNI unless the distribution is required to be made or is actually made in more than 3 installments. So that's a big one. You have to watch out if you're administering an estate or trust, how many installments you distribute a pecuniary gift. Obviously, drafting, you can say somebody gets $100,000. That would generally not carry out DNI when we satisfy it, but if it's satisfied in $40,000 increments, or excuse me, $33,000 increments, then it would still be okay. If it's satisfied in $25,000 increments, then there would be DNI. The payment of interest on the delayed funding of the pecuniary gift is income to the recipient. Okay, so that they are going to get income, the recipient, from that interest of 7%. The IRS takes the position that the interest paid by the estate or trust is personal interest and therefore not deductible. It used to be that it was personal interest and it would be deductible, but under the rules that have subsequently come into play, that income is no longer deductible because it does not fall within the appropriate bucket under Section 163H. And so you want to try to avoid that where possible, which means satisfying pecuniary gifts within 1 year to avoid the payment of interest where possible. Next slide. Satisfying a pecuniary gift with an appreciated asset. So let's say the gift is $100,000. When somebody dies, the basis of property gets stepped up or down to fair market value. Let's say the basis of the property is 80, and we use that asset because it's grown in value to 100 to satisfy a gift of 100. Well, that's treated as a deemed sale by the estate or trust, such that 100 of gift satisfied, 80 basis, there'd be 20 of gain. And under the Keenan case, Keenan versus Commissioner, the gain does not pass out. It's not an item of DNI, and it is borne by the estate or trust that has made the gift. There is not necessarily an equivalence if the property has gone down in value. Because of the related party rules under 267. Next slide, please. The gain will, the loss will be allowed only if it's an estate transaction under 267. Finally, the satisfaction of a residual gift does carry out DNI regardless of what's distributed. It's the value of what is distributed, not the nature of the property, that is determinative. So, for example, if you have a residual beneficiary who's going to get $100, the same tax treatment will occur if a painting worth $100 or some other property worth $100 is distributed. For income tax purposes, when we satisfy that gift to the residual beneficiary, then that's treated as a distribution of $100 of DNI. And by the way, I mentioned earlier about the quantification of income. The simple way to remember it is if the trust has 75 of income, the rules are that there's 75 of income to be allocated. We don't know whether that income is all going to go out to the beneficiary because it's part of the DNI that gets distributed, or it's all going to stay in the estate or trust, but the maximum amount of income is 75, subject to the Keenan rule if there's a Keenan gain. So that if the beneficiary receives $1 million distribution from an estate or trust, and the estate or trust only has $40,000 of income, then we're only talking about $40,000 of income to be apportioned, not $1 million. Next slide. So here is the separate share rule. If we have an estate that's distributable equally to my issue, and let's say all 3 children survive, so each gets 1/3. In that situation, if we have $120 of income of the estate, then each child's 1/3 share is 40. So if we make a distribution of different amounts to different children, it's not certain that all the DNI will pass out to the beneficiaries. Again, you'd think, oh, look, and you look in the distribution column, there's 140 being distributed, and the DNI is 120, so all the DNI goes out to the beneficiaries. That's not the case here. Why? Because in this case, Alex gets 95, which is in excess of their share. They do get all the DNI for their share. Blake, however, only gets 30, where their share of their DNI is 40, so that means that 10 is left in the estate, and Cameron gets 15, so that they will receive DNI of 15, but 25 of their DNI stays in the estate, and the estate ends up getting taxed on 35. The beneficiaries cumulatively will have income of 85 to pay tax on. Next slide, please. Okay. Now I'm going to move to slightly more complicated issues involving the marital deduction. And a married individual often utilizes a plan that provides for a portion to be subject to tax at the first death and not at the second death. Now, some of that may not be done anymore because of portability, but there are issues with portability. You have to file an estate tax return to claim it. If the surviving spouse remarries and then that second spouse predeceases, the first spouse's credit that was ported gets lost, and the surviving spouse will be left with the second spouse's unused credit, if any. So there are all sorts of issues there beyond the scope of this presentation. So I'm going to go back to the typical AB or marital credit trust situation with it may not be needed for many clients who have smaller estates, but by the way, if the plan, regardless of need, has an AB trust or marital trust and credit trust, then post-death it needs to be implemented, even if it wasn't needed. So the example there is if the husband and wife today combined have a $10 million estate, they don't need a marital trust and a credit trust. They could just give it all outright to the surviving spouse or put everything in a credit trust or a residual trust of the decedent's property, and it would all work without any adverse tax consequences. But if they have a different plan, then it has to be implemented. Next slide, please. So the three trusts that we typically create are the survivor's trust, which hold the surviving spouse's property, the credit trust, which holds the deceased spouse's property that's subject to estate tax. Again, that would be up to $13.99 million today. Next year, that number goes to $15 million, and thereafter the amount will be $15 million with the annual cost of living adjustment. And then finally, the marital trust, which holds the deceased spouse's property that qualifies for the marital deduction in excess of the amount that passed to the credit trust. Next slide. Initially, practitioners post-death could play games. How could they play games? There was a limited marital deduction, and in community property states, you didn't get much of a marital deduction because the surviving spouse was already deemed to have their half by virtue of their half of the community. They changed all of that in 1981 with the unlimited marital deduction, but practitioners could still play games by taking an asset that had a value on date of death of one thing, but had a different value and a lower value at the date of funding, to use that to satisfy the gift. And these games, the IRS put a stop to in 1964 through Rev Proc 6419. So now the division must be made in one of several ways. Next slide, please. First, you can have, and I'm going to come back to these things, A, B, and C, and the types of funding. So you have, first of all, what type of gift? It's a non-marital pecuniary is the A, non-marital pecuniary. Basically, the credit trust is a pecuniary gift. I give, simply put, 1399 for, we'll call it 14 million. I give 14 million to the credit trust, and that means the residue would be the marital trust, funded using either date of distribution or fairly representative funding. We'll talk about what these mean in a moment. Date of distribution, as the name implies, is the date that actually the gift is funded. And the fairly representative is a little bit more complicated and requires that the gift be funded using assets fairly representative of the appreciation or depreciation post-death. The second way of doing this, the B thing, is a marital pecuniary. I give to the marital trust everything in excess of $14 million. So again, the A is I give $14 million to the credit trust, everything else to the marital. B is I give everything in excess of $14 million to the marital trust and the balance to the credit trust. Here again, date of distribution funding, that also fairly representative funding, and something called minimum worth funding that we'll talk about in a slide or two. And then finally, it can be a fractional, which is both gifts are residual and funded by fractional funding or pick and choose funding, which probably works. We'll talk about each of these in a moment and the consequences. If you're a drafts person, you should know what you're using and why. If you are getting a document that's handed to you, it doesn't really matter what somebody has. You're going to have to play out what they have. and go with that. Next slide. So date of distribution requires assets to be used to fund the pecuniary gift at the date of distribution. As the name implies, there's a single target, which is the date of distribution value. So if we have a $14 million gift, to the credit trust, then you need to find assets that on the date of distribution have $14 million value. And by the way, some assets today may be valued at $8 million and we distribute those, and then you need $6 million down the road. Don't forget, as Julia talked about before, this is a pecuniary gift, so it's not satisfied within 1 year. It's going to get interest. For the date of distribution, we only have to value the assets once on the date of distribution and the date of death. Okay, but there's only a second valuation on the date of distribution. May result in keening gain if there are appreciated assets. Next slide. For fairly representative, it's actually two constraints. For the date of death, there's one constraint. Look at what the date of death value is. For fairly representative, we first need to look at the date of death values, and we need to look at the date of distribution values to find out what the overall appreciation or depreciation in the assets that could be used is. Without knowing what the overall appreciation or depreciation is, we can't select assets that are fairly representative of that overall appreciation or depreciation. And so we have the two targets, again, both of them, and requires valuation of all assets available for distribution. So whereas in the date of distribution, you only need to value the assets actually being used to fund the pecuniary gift, here you need to revalue all assets. Again, potentially a greater cost. Next slide. Also, the fairly representative may limit funding options. So the simple example is you have two assets, they both have the same distribution, same date of death value, but one has gone up by $20 and the other has gone down by $20. The only way you can get fairly representative, which is no overall appreciation or depreciation, is to take equal parts of A and B. That's the only way you can do it. And so your hands are tied. You could not use 40% of A and 60% of B or any other thing other than X percent of A and X percent of B to satisfy fairly representative. Okay. When you have more assets, then obviously you can potentially get the fairly representative in different ways. Perhaps, again, you need to look at those assets and see what's available. Next slide. Okay, minimum worth. So date of distribution and fairly representative are available for both A, which was the marital, A, which was the credit pecuniary, and B, which was the marital pecuniary. But minimum worth can only be used for the marital pecuniary. Here, we value each asset at the lower of its basis and date of distribution value. Again, it requires two different appraisals, potentially one on date of death, which is the basis, and another on the date of distribution. It likely overvalues the property to the marital trust, which is one of the reasons why the IRS approved it. And by overvaluing the property to the marital trust, undervalues the property to the credit trust. So not the optimal estate tax result. And I would therefore, as a draftsperson, not recommend this in most cases. Next slide, please. The last this is some examples of the going back. Sorry, before we get to that, you don't have to go back on the slide. The other possibility is fractional, where there's two possibilities of funding. One of them is again the 4, which is the fractional of everything, and I refer to that as the hacksaw approach. That if the relative values of the credit trust and the marital trust are 2 to 1, then each and every asset gets allocated in that 2 to 1 ratio. Doesn't matter what it is. Completely fair, completely objective. Nobody's going to complain because whatever. The other one is pick and choose, which is that you basically you do fractional, but you can potentially pick some assets to satisfy parts of the gifts, and it doesn't have to be a pro rata funding. The first one has to be pro rata funding. Second one is non-pro rata funding. That has not been expressly and explicitly blessed by the IRS. It probably works, but not 100% sure. So let's go through these. A1, again, A, B, C, and D refers to marital pecuniary, excuse me, credit pecuniary first. B is the marital pecuniary, and C is the fractional. So if we assume that the value of the estate has gone up from 25 to 30 million, there's gone up in value by 5 million, scheme A1 is that the date of distribution satisfying the non-marital gift the marital gift, excuse me. Let me take a step back. If we satisfy the non-marital gift with a pecuniary amount of $14 million, it gets $14 million. The residue, which is now $5 million more, goes to the marital trust. Next option is that if we use fairly representative, you can see that the non-marital gift shares in some of the growth, which is a generally good result. We generally want to have the non-marital gift higher. If you go to the B funding scheme, the marital pecuniary, then we see if there's a $5 million growth, the entire $5 million goes to the residue and goes to the non-marital gift, which is a great result. If we use fairly representative, then we have the same results as in A2. B2 is the same as A2, but again, we have differences. You can hit return because the one gift is pecuniary, and so there's income differences. And then for B3, we don't really know whether it's going to be more or less in the marital trust. You can hit return again. It's possible that the marital trust could eat up everything, and the non-marital trust could be as little as zero. Again, it could be that if we have enough cash, it could be that only $11 million goes to the marital trust. With the two fractional, you can hit return twice, we're going to get the same 13.2 and 6.8. Both of them are treated as residual gifts, the marital gift and the non-marital gift. Now, let's notice, by the way, that you have a great result in B1 if there's 5 million of appreciation, and in A1 you've got a limiting gift of $14 million if you have the non-marital gift as pecuniary. Let's go to the next slide, which is the value has gone down by $5 million. Here, notice we preserved the non-marital gift under A1, and the entire hit is borne by the marital trust. Under A2, that's reversed. If you can hit return, and you're going to see that the A2 is fairly representative. A2 is fairly representative, so they both take a share of the hit. B1, where we have the marital gift is the pecuniary gift, it's going to get what it's supposed to get, and the residue gets any gain or loss or any growth or depreciation. Hit the return, please. You're going to see that it gets only 9 million. And then the fairly representative in B2, again, the same results, different on income. B3, again, we don't know how much of the 20 million will go to the marital trust. It could be all. And then in the fractional, you're going to have the same results of 8.8 and 11.2 in both instances. You can hit return twice. But notice that what was so good in B1, if it went up in value, was the worst result if it went down in value. And what was just a limiting result gave extra to the marital trust in A1 was a really good result if things go down in value. So part of deciding what to use, you have to make some predictions. The fairly representative or the fractional aren't nearly as good on the upside, but also protect against the downside. Next slide. So now generation skipping transfer tax. There are GST implications for the nature of the gift as well. Very brief overview of the GST tax. The tax itself is the amount involved times the applicable rate. The applicable rate equals the highest estate tax rate, which is currently 40%, times the inclusion ratio. The inclusion ratio is 1 less the applicable fraction, and the applicable fraction is the GST exemption allocated divided by the value of property transferred as adjusted. So again, a lot of definitions there in getting to the actual amount of tax. It is good to have an inclusion ratio of 0, so it's good to have an applicable fraction of 1, i.e. the GST exemption allocated divided by the value of property is 1. We have $1 million of property. We allocate $1 million of GST exemption to it. The applicable fraction is 1. The inclusion ratio is 0. Means that there's no GST tax. Obviously, if there's no GST exemption allocated, then the inclusion fraction is 0. The inclusion ratio is 1, and the applicable rate is 40%. Next slide, please. The applicable fraction, what is the denominator? For the pecuniary gift satisfied with cash, the denominator is the pecuniary amount. If it's satisfied with something other than cash, then if the gift must be satisfied using date of death or fairly representative funding, denominator is the pecuniary amount. Again, it's somewhat easy. If pecuniary gift was satisfied other than cash, and the gift is not required to be satisfied using date of death or fairly representative funding, then the denominator is the date of distribution value of the property satisfying the pecuniary gift. Next slide. So notice the date of distribution. Residual gift after pecuniary gift that carries appropriate interest, the denominator is the date of death value of the property available to satisfy the residual gift reduced by the pecuniary amount. Okay, and appropriate interest can either be state law 7%, satisfied within 15 months after death. So if we somehow have a document that overrides California law, if it's satisfied within 15 months after date of death, it's still okay. Or if the pecuniary gift receives a pro rata share of the income from the fund from which it is satisfied. Again, that would only typically happen in a residual gift. So maybe it's actually going to work. And then there's special rules for residuals. I'm not going to go through these other rules. We're a little bit more detailed because we're running out of time, and I do want Julie to have a chance to finish up. So if you can go through the remaining generation skipping transfer tax slides, which are in your material, maybe it was only the one, they're also talked about in the outline. Julia?
Okay, and finally, to sum up, when can estate distributions be made? Must generally be made after obtaining a court order. However, and they can be made using the notice of proposed action procedures under the following circumstances: if the time for filing creditors' claims has expired, the personal representative determines that distribution won't cause loss to creditors or injury to the state or any person, and or you're just to distribute the following property, basically income received during administration to the persons entitled to that income, tangible personal property, including vehicles with a total value of $50,000 or less, and cash to satisfy a pecuniary bequest not exceeding $10,000 to any one person. So that's general overview of when items can be distributed.
And again, those rules all follow the fiduciary rules that Julia started off with at the beginning. I see that there's one question in the chat. It takes a partial mortgage. I'm not sure I understand what a partial mortgage is. On a previously fully owned property that was specifically devised. So the answer is that a mortgage follows the property. So that if there's a house and it's subject to a mortgage, even if there's a general clause in the will or trust saying pay all debts, the beneficiary of that property takes the mortgage. I don't know if that answers that. I'm not sure what a partial mortgage is, if that's something different than a regular mortgage. Any other questions? Thank you for your time.
Thank you, everyone.
All right, that concludes today's presentation. Thank you so much, Mark and Julia, for your time today, and thank you to our audience. Have a great morning, everybody.
Thank you.
Thank you.